Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Happy week 212. This week, after the FBA Immigration Conference, my wife and I went to Park City, Utah, and then Jackson Hole, Wyoming, to hang out in the Grand Tetons. A phrase that I now know means something very different in the original French. As many of you likely know from experiencing it yourselves, it was all epic. A bit of a baby moon for us. That's right, we're expecting. Might hear some cries in the background of the podcast going forward. Any advice on how to be an immigration attorney and raise a human is warmly received. And the pod must go on. Seriously, I have contracts. So I've got 4 interesting cases for you all this week. But before I do, and it's not immigration related at all, but I personally couldn't stop laughing at reports that Red Lobster has closed 100 stores. Not laughing at the company, and certainly not the employees who have been laid off. That is a tragedy, and I wish all of those employees new and better jobs soon. But in reporting the matter, The Hill states that in addition to COVID-19 shutdowns and high interest rates, quote, there was the endless shrimp fiasco. In June 2023, the company offered its ultimate endless shrimp, typically a limited offer, on their regular menu for $20. The attempt to get more people into the store worked, but it came at a cost. Red Lobster posted an operating loss of more than $11 million in Q3 of that year. The endless shrimp deal was a key factor in creating that loss. End quote. That's just good writing. And if you can't laugh at the irony of Red Lobster being done in by endless shrimp, well, maybe you don't know what humor is. And here are the cases. Kicking it off with Sorto-Vasquez Kid et al. V. Mayorkas et al. Out of the Central District of California on May 15th, 2024. It was another short week, or so I thought before Friday afternoon. In any event, I took another dip down into district court. Of course, for some non-citizen good. A judge in the Central District of California granted summary judgment to a non-citizen and some advocacy entities' challenge of ICE's practice of showing up at non-citizens' homes and asking to speak with non-citizens in the Los Angeles area. Knock and talks, according to ICE. More like, quote, knock and arrest, end quote, according to the federal judge. And it's not constitutional. Again, this is about how ICE conducts itself in the Los Angeles area, but based on the facts here, it seems like this is what ICE is doing nationwide. And so while the actual relief granted by the district court in this case is limited to that area, it seems, that is the Central District of California, it does seem like this case might have nationwide effect. Here, the plaintiffs alleged and then proved, sufficiently, that ICE regularly does 2 things in Los Angeles. They act like police or probation officers to trick non-citizens into granting them access to their home or similar property, or they enter the constitutionally protected area around a non-citizen's home without a warrant and do their knock and talk thing. Then often they arrest them under suspicion of some type of immigration violation. ICE internal policy tells officers that this latter thing is okay, so long as they're doing no more, initially, than, say, a mailman or someone trying to sell you something would do, that is, coming to your door and asking to speak with you. The evidence in this case shows, however, the true purpose of many of these encounters is to effectuate an immigration arrest of a non-citizen. ICE officers almost never have judicial warrants to do this, that is, actual warrants signed by a judge to come up to a non-citizen's home. Sometimes they have administrative warrants, which are complete misnomers and are in no way actual warrants authorized by a neutral arbitrator, much less a judge. According to ICE training, this is one of the 4 major ways that ICE effectuates detentions of non-citizens, that is, this knock and talk thing. The record here had many examples of how this works in practice, but here's one, quote, "On February 17, 2017, ICE officers approached the back entrance of Diana Rodriguez's home, which is only accessible by entering the backyard. After her girlfriend answered the door, an officer asked Ms. Rodriguez to step outside, answer some questions, and provide the officers with identification. After Ms. Rodriguez stepped outside, the officers took her into custody," end quote. This and the other events described in this decision are completely consistent with ICE policy and training, and so, I imagine, again occur nationwide. They're just unconstitutional, said the district court. Something the district court said after certifying classes in a class action, by the way. And that's no small thing to achieve. Surprised ICE didn't try to settle this after certification. Who knows, maybe they did. But it all went to summary judgment regardless, and the court granted it to the non-citizens and the non-citizen advocacy entities. All of it turns on the fact that the federal court judge doesn't believe that ICE is actually entering the protected area around homes merely to talk to non-citizens, but rather to effectuate an arrest. This seems heavily supported again by the evidence in ICE's own training, as it must for a federal judge to grant summary judgment on the issue against ICE. The court believes this unconstitutional. After all, quote, "At the core of the Fourth Amendment stands the right of a man to retreat to his own home and there be free from unreasonable government intrusion," end quote. Woman, too, I suppose. Although we'll see how far states take social media and tech surveillance after Dobbs, right? Anyway, can't search or seize a home without a warrant. Black letter law thanks to the Warren Court that the current court is at war with. Okay, I'll stop. As we all know from Con Law or Crim Pro 101, the protection around a home, this Fourth Amendment protection, extends to the curtilage, which is essentially the part of the home that immediately surrounds the home. There is no question here that ICE is entering the curtilage, and it seems that there's not really a dispute in this case that ICE is doing so with the intent of arresting non-citizens. ICE argued, however, that they have an administrative warrant that allows them to do so, making it all okay, and that in any event, they're getting consent from the occupant before they arrest. The thing is that the court doesn't believe that this ostensibly, quote, "consensual encounter," end quote, is proper in the first place. Plus, to that first point, even ICE in this case expressly said that, quote, "it will not argue or claim that an administrative warrant provides legal authority to enter a residence or other location in which an individual has a reasonable expectation of privacy," end quote. Remember that concession, everybody, both in future litigation and in removal proceedings. Even though there's some precedent that might undermine excluding the fruit of this type of poisonous tree in removal proceedings, it's still an important concession from ICE. An administrative warrant doesn't give them legal authority to enter protected areas. In any case, explained the court, no, administrative warrants don't permit ICE to enter a home or, importantly, the curtilage. Non-citizens are still due these protections unless or dare, I say, until the Supreme Court says otherwise. And that day is not today, and it is not this term. Okay, but what about the fact that after the encounter at the door, the occupant consents to this talk and to the non-citizen coming outside the home? And it is true that there are implicit licenses for people to come to our doors and talk to us in America. Police officers enjoy the same implicit consent as do ICE, apparently. And just so everybody knows, though, just like someone trying to sell you something at your door, you can always tell ICE or a police officer to leave through your locked door. But in the Ninth Circuit, at least, this implicit license to come to someone's door is limited to knocking and asking a couple of questions. If the officer, or anyone else really, has another reason for their knock, then they don't have this implicit license to come onto your curtilage. Explain the district court, and that's what's happening here. ICE can't benefit from some of the more law enforcement friendly precedent in the removal proceeding context that would seem to say some of this is okay, because this here isn't about removal proceedings or excluding evidence. This is about stopping constitutional violations in the first place. The court also believes that all of this violates ICE's own regulations, or that is to say, the court reads ICE's regs as requiring an actual warrant to do these things in order for that reg to be constitutional. ICE's practice also violates the Administrative Procedures Act, explained the court. So what to do about it all, postulated the court. No easy analysis anymore, given what the Supreme Court recently said in Aleman Gonzalez about I&A Section 242F, i.e., a district court can't enjoin the U.S. government if doing so would, quote, interfere with ICE's efforts to operate, end quote, certain specified immigration statutes. Quite the holding in Aleman Gonzalez, no? Kind of flew under the radar there on episode 112. But injunctive relief in this case would not violate I&A Section 242F, explained the court. The plaintiffs here aren't challenging removal orders or removal proceedings in the first place, things that would be covered under I&A Section 242F and therefore can't be subject to injunctive relief. This case here is simply about the way that administrative warrants are executed, a way that the district court believes is unconstitutional and which is not one of the specified things covered by Section 242F. Even Aleman Gonzalez says that federal court judges can do this, that is, grant injunctive relief, if there is only collateral effect on ICE's actions that are covered by Section 242F. This is such a thing. Arresting non-citizens is collateral to the other things that ICE is totally permitted to do without federal court review after Aleman Gonzalez. After some more analysis about its own authority, the court decided to do the following. Hold the ICE practice unconstitutional, and then vacate all practices, policies, and presumably trainings used by ICE, CRO, HSI, or anyone else really operating in the Los Angeles area. That is, you can't enter the curtilage of a non-citizen or anyone else's home without express consent from a resident of the home, without a real warrant, if ICE has, quote, the purpose of arresting an occupant, end quote. It was a long one, I know, which is one of the reasons I don't do district court decisions very often. But remember this decision. And that is Sorto-Vasquez Kid et al. V. Mayorkas et al. All right. Gonna flip it 180 degrees now and do matter of Furtado, published by the BIA. This case is about Hague adoptions, something I know something about, but am certainly no expert in. A sentence that pretty much every immigration attorney I know would say themselves. Be honest. As an adoption case, it originates with USCIS. A U.S. citizen grandmother adopted her grandchild in 2017, who is from the country of Cabo Verde. The grandchild was already in the U.S. at the time, having entered as a tourist in 2013. After the adoption, the grandmother filed a Form I-130 petition for her grandchild, seeking to classify him as the adopted child of a U.S. citizen and thereby put him on a path to a green card and maybe even automatic U.S. citizenship. Here's the thing, though. Cabo Verde, like the U.S. and many but not all countries, is part of the Convention on Protection of Children and Cooperation in respect of inter-country adoption. I just refer to Hague Act adoption. For Hague Act adoptions, there are certain requirements that must be met before USCIS will classify the purportedly adopted child as a child for immigration purposes, as defined at I&A Section 101B1E. USCIS deemed those requirements unmet here, and so denied the grandmother's I-130 petition for her grandchild, and the BIA affirmed. There are lots more requirements to get an I-130 approved in the case of a Hague Act adoption. Similar hurdles exist for Hague Act adoptions and N600 certificates of citizenship. The whole point of these requirements is to ensure that proper adoptions are occurring and that children aren't being exploited. To get an I-130 approved for a Hague Act country, it's quite rigorous. Here's what the BIA explains, citing to the regulations. In addition to an I-130, the petitioner must file a Form I-800 and Form I-800A. The Form I-800A must be filed with documentation that a home study has been completed. Once the I-800A is approved, the petitioner must apply to obtain proposed adoptive placement with the Hague Act Convention country of origin's central authority. The I-800 petition to classify must also be filed before adoption. The I-800 process applies even when a child is present in the United States, provided the child's habitual residence immediately before arrival in the U.S. was in a convention country. All of this is not for the faint of heart. That's me now. There are limited exceptions, but yeah, this is all very complicated. Certified adoption agencies know how to do it, though. But what if you're a great-grandmother caring for your grandchild and you're just trying to adopt your grandchild to care for him and give him a better life? Better follow the rules to a T, explains USCIS and the BIA. Sometimes law really becomes form over substance. But there is an exception to all that process. Quote, if the petitioner shows that at the time of the adoption, the petitioner was not habitually resident in the United States, or the beneficiary was not habitually resident in a convention country, end quote. The grandmother here was a resident of the U.S., and it seems that she definitely didn't comply with all the process. So the question here is, was the grandson beneficiary habitually residing in the United States? If so, and despite the U.S. being a convention country, which is therefore very confusing to me, the I-130 could be approved. As a matter of substance, it seems that there really is no question that the grandchild was habitually residing in the United States. But again, this is form over substance. And USCIS has a regulation to make this determination. Pursuant to 8 CFR section 204.303b, quote, a child whose classification is sought is generally deemed to be habitually resident in the country of the child's citizenship. If the child's actual residence is outside the country of citizenship, the child will be deemed habitually resident in that other country, rather than in the country of citizenship, if the central authority, or another competent authority of the country, has determined that the child's status in the United States is sufficiently stable for that country, that is the United States, to exercise jurisdiction over the child's adoption or custody, end quote. Confusing stuff. And to do that analysis, USCIS is generally required either a written statement from the country's central authority, whatever that is, or an adoption order incorporating the central authority's statement. Boiled down, the Hague Act, as interpreted by USCIS regulations, is trying to make sure that the home country approves and that they are involved. There's still yet another exception. Remember, we're already in exception territory right now. Quote, if the petitioner does not submit a letter from the designated central authority in the child's country of origin, USCIS requires a showing that the central authority did not respond to the request for a habitual residence statement, that the central authority responded that it would not write a habitual residence statement, or that the United States Department of State has confirmed that the central authority does not issue habitual residence statements. End quote. All very country-specific and complicated. All of this talk of central authorities is giving 1984. These are USCIS's policies, and while they're not binding on the BIA deems, quote, this particular policy requirement persuasive in this case, end quote. It's consistent with what the BIA believes are our country's obligations under and are the purposes of the Hague Act. So, what this decision holds is that the BIA will now officially require all of this for relevant I-130 petitions, which USCIS was apparently already doing anyway, but now it's official. And it's all required no matter how long the child has been in the United States. That is, you've got to comply with the I-800 and the I-800A Hague Act adoption stuff for Hague Act countries. If you don't, you need to incorporate the central authority and get those statements. And if you can't do that, you need to show that you tried sufficiently. That's way dumbing it down, and of course read the decision. It wasn't established here, hence the issue. Now true, the grandmother did prove that her grandchild that she adopted had been living in the United States since he was very young, but she didn't even try to get the Cabo Verde Central Authority involved. A technicality with seemingly legitimate reasons, but a technicality nonetheless that results in this seemingly valid grandmother-grandchild adoption not being recognized for I-130 immigration purposes. Now, it seems that after USCIS denied the I-130, the grandmother then indeed did try to get in contact with the Central Authority of Cabo Verde, but that all of her attempts were not successful. And maybe that will satisfy USCIS here, although they might need to incorporate the U.S. Department of State as well. But for purposes of this decision, the BIA refused to accept or consider this new evidence submitted for the first time on appeal. The grandmother can file a new I-130 petition for her grandchild, explained the BIA. Hopefully the grandchild has not aged out, explained the Kevin. And that is matter of Furtado. We all know the immense dedication it takes to be an immigration lawyer. You fight tirelessly for your clients, their families, and their futures. But let's face it, the administrative side of running a practice can feel overwhelming. Mountains of paperwork, endless calls, juggling deadlines, it can easily steal your focus and leave you feeling burnt out. But what if there was a way to simplify all of it? I want to tell you about FileVine, a legal case management platform specifically designed by lawyers for lawyers. FileVine keeps all case information centralized in one place. Plus, FileVine's immigration-specific tool, Immigration AI, uses the most advanced AI-powered technology to extract vital information from passports, birth certificates, and other essential documents and automates USCIS form filling through smart questionnaires available in up to 170 languages. Pretty impressive. FileVine and Immigration AI can give you back precious time and energy, allowing you to focus on what matters most, your clients and their cases. So if you're ready to reclaim your time and rediscover the joy of practicing immigration law, head on over to immigration.ai/immigration review. Links in the show notes. Say goodbye to missed calls and wasted time on unqualified consultations. With Staffy Live, you get a dedicated team of truly bilingual and highly empathetic specialists answering the phones for your immigration law firm 24/7. Staffy Live specialists go beyond just answering calls. They qualify callers by asking the right questions, ensuring that only qualified consultations make it into your calendar. Plus, they don't stop there. Staffy Live can also handle follow-ups, so you can focus on what you do best, practicing law. Staffy Live is a service for immigration law firms only. And here's the best part. You can try Staffy Live absolutely free for 15 days, no strings attached. Just visit www.staffy.cc, that's stafi.cc, and click Get Started. Of course, use the code FREE to claim your free trial, or click on the links in the show notes. Next up is the Djokro v. Garland, published by the First Circuit on May 17, 2024. This case is about motions to reopen. Mr. Djokro and his son are from Indonesia. Seems like they entered separately as tourists in 2006 and 2007, and they overstayed. They sought asylum and removal proceedings, and they were denied. Seems like their claim was based on their Chinese ethnicity and Christian faith, specifically Catholicism. The BIA and even the First Circuit affirmed, albeit in the latter case, for failure to prosecute their petition for review. At around the same time that the BIA affirmed, the Djokros filed a motion to reconsider, which too was denied. The basis appeared to be largely that Mr. Djokro's other son had recently been granted asylum separately. Still no dice worthy of reconsideration, said the BIA. They filed a motion to reopen with the BIA shortly after that, arguing that conditions had deteriorated for Chinese Christians in Indonesia in 2012. denied again. Remaining in the United States, the Djokros filed another motion to reopen in 2021. The BIA denied that too, notwithstanding a 2023 supplement of evidence. And now, on petition for review, the First Circuit affirmed that denial. Changed country condition motions to reopen require a showing that conditions have changed materially for a non-citizen such that now they can establish a prima facie showing for asylum, or withholding of removal or cat protection. In the First Circuit, this probably needs to be based on evidence that conditions have, quote, intensified or deteriorated since their merits hearing, end quote. The evidence must be material and must have been previously unavailable. To the First Circuit, the BIA properly analyzed the evidence submitted and reasonably held that the Djokros hadn't met their burden. For example, it wasn't crazy for the BIA to give less weight to worse conditions in 2017 and 2018, and more weight to the evidence of conditions from 2021 and 2023, where the BIA was adjudicating something in 2023. And the 2023 evidence to the BIA showed that conditions were similar to what they were at the merits hearing in 2009. And, quote, to the extent that petitioners provided evidence that a more fundamentalist version of Islam had become more popular among youth in recent years, the BIA reasonably found that petitioners had failed to establish a connection between that development and the alleged deterioration in conditions for Christians specifically, end quote. All of these holdings notwithstanding the First Circuit's 2018 decision in Sihotang v. Sessions. In that case, the First Circuit reversed the BIA's denial of a motion to reopen filed by an evangelical and proselytizing Indonesian Christian. It was distinguished here. The BIA and the First Circuit found Sihotang, quote, distinguishable because petitioners here had not purported to be evangelical Christians or argued that their form of Christianity would involve actions such as proselytizing, end quote. A similar rationale was used to reject the unpublished BIA decisions that were submitted, that appear to show that the BIA has been sometimes reopening and remanding the asylum claims of Indonesian Chinese Christians. Always a smart thing to include in your changed country condition motion to reopen, though. That is, unpublished BIA decisions granting such action to similarly situated individuals. To the First Circuit, though, most of those unpublished cases involved Chinese Christians who had been living in the U.S. under a humanitarian program called Operation Indonesian Surrender. Those people's identities had been made public in Indonesia, as was a lawsuit that they filed in the United States, so they were at increased risk. Not the case for the petitioners here. But doesn't the risk then increase the second the First Circuit publishes this decision with their identities? Anyway, quote, the unpublished BIA decisions are also not even a representative sample, as they do not include unpublished decisions finding no changed country conditions, end quote. And in any event, each asylum case must be decided on its own specific facts unless it's a pattern or practice case. The Djokros, therefore, lost their case. Friendly reminder, though. To the extent you would like your First Circuit Indonesian Christian case or motion to reopen to fall within Sihotang, and therefore possibly succeed in the First Circuit, that case again was about, quote, evangelical Christians who argued that their form of Christianity would involve actions such as proselytizing that would put them at increased risk of running afoul of the increasingly harsh blasphemy laws in Indonesia, end quote. And that is the Djokro v. Garland. Concluding, as we must, with a bit of a long one out of the Fourth Circuit. Marquez, Cruz v. Garland, published by the Fourth on May 14th, 2024. This case is about crimes of child abuse, neglect, or abandonment. Mr. Cruz is a lawful permanent resident originally from El Salvador. Seems like he came as a child, but years later, at 26 years old, he began a relationship with a 15-year-old. When the mother of the girl learned, she pressed charges, and while out on bail, Mr. Cruz violated a protective order by rekindling his relationship with the 15-year-old. He eventually pled guilty to attempted second-degree child sexual abuse under District of Columbia Code Section 22-3009 and 22-3018. He received a sentence to 18 months incarceration with lots of supervised release, although all of it ended up suspended to time served. Seems like a decent result for Mr. Cruz in the criminal context, but for immigration purposes, it's a big problem. DHS alleged that it made Mr. Cruz removable as both a crime of child abuse, neglect, or abandonment, and as an aggravated felony, sexual abuse of a minor. The IJ sustained the child abuse ground, dismissed the aggravated felony charge, and denied LPR cancellation of removal. The BIA affirmed. But the Fourth Circuit sent it back to the BIA to consider some of Mr. Cruz's smart arguments. On remand, though, the BIA affirmed the IJ again and rejected those arguments. As did now the Fourth Circuit. The categorical approach applies to the analysis regarding whether a state or DC crime matches the federal definition of a crime of child abuse, abandonment, or neglect, as used at I&A Section 237A2EI. As the BIA has now held for over a decade, and as the Fourth Circuit deems reasonable, this phrase, child abuse, abandonment, or neglect, with clearly three different things, actually refers to a single crime with single elements. To the Fourth Circuit, then, that means that, quote, the intended sweep of the term must be broad enough to encompass all three of the listed offenses, abuse, neglect, and abandonment, end quote. Looking briefly to dictionary definitions from 1996, the Fourth Circuit goes on to explain that, quote, given these definitions, it is not necessary for a child to have been actually harmed, end quote. The BIA has said the same thing. Hence, the neglect or abandonment, explained the court. A criminal statute that requires a threat of or a risk of injury is sufficient. Or as the Fourth Circuit put it, quote, a crime of child abuse requires an act or omission that either injures a child or creates a sufficiently high risk that a child will be harmed, end quote. This aligns with all circuits to have addressed the statute, believes the panel, although it got really confusing there for a minute in the Ninth Circuit. So anyway, that's our federal standard for child abuse removability. The first step needed of the categorical approach. Into that federal definition, DHS must fit all the elements of the DC offense. If they don't fit, you don't have a match. Stealing from Texas Attorney Jordan Pollack here, imagine that the federal definition is a box, and that the state crime statute is a fat cat. DHS is trying to stuff that fat cat into the box. But if some of that cat fat is overflowing and it just won't fit in the box, well, you have an overbroad state statute. And you have a non-removable offense. If that helps. If it doesn't, blame Jordan Pollack. Mr. Cruz's attorneys argued that the cat was too fat for two reasons. First, Mr. Cruz argued that attempt offenses cannot satisfy the actus reus requirement of I&A Section 237A2EI because Congress failed to expressly include attempts in that statute. Second, Mr. Cruz argued that statutes that impose a strict liability as to a victim's age, like the DC offense apparently, cannot satisfy the mens rea requirement of the removability provision because they do not require a culpable mental state. See how complicated immigration can get? The Fourth Circuit rejected both arguments. First, attempt. The Fourth Circuit believes that the I&A's child abuse definition includes it because, again, the removability provision doesn't require actual harm to a child. It includes criminal statutes that only criminalize a reasonable probability of harm to a child. Quote, this definition logically extends to attempts. Here is how. Take an offense that no one disputes causes an actual physical injury to a child, say an offense of physically beating and bruising a child. If a person attempts to physically abuse the child, say by throwing a heavy object at the head of that child, he has created at least a likelihood or reasonable probability that the child will be harmed even if he misses, end quote. And I guess that person could be convicted of attempted beating in the hypothetical state? Anyway, for the statute at issue here, quote, the minimum conduct criminalized by this statute is touching the private areas of a 15-year-old child over the child's clothing with an object and with the intent to gratify any person's sexual desire, end quote. That's child abuse if completed, explained the court. But again, the actual conviction was attempt. And statutes that criminalize any risk of harm to children don't cut it for the removability definition. The risk must be a, quote, reasonable probability, end quote. Therefore, the Fourth Circuit, for an attempt crime to qualify, the, quote, relevant jurisdiction's definition of attempt must require a likelihood or reasonable probability of harm to a child, end quote. Met here, although that's a standard I bet is not met in other states or with other statutes. Quote, to convict the defendant for attempt in D.C., the government must prove that the defendant, 1, intended to commit the crime, 2, committed an overt act towards completion of the crime, and 3, that the defendant came within dangerous proximity of completing the crime, end quote. To the Fourth Circuit, that dangerous proximity requirement equates to a reasonable probability that harm will occur. In D.C., it means that, quote, except for some interference, a defendant's overt acts would have resulted in commission or the completed crime, or where the defendant has taken a substantial step towards commission of the crime, end quote. So it's a sufficiently culpable attempt requirement in D.C., but again, maybe not in other states. To the Fourth Circuit, it didn't matter that Congress didn't include the word attempt at I&A Section 237A2EI. You need to look at the statute as a whole, explained the Fourth Circuit, to determine what Congress's intent was. While Congress expressly included attempts at some other removability provisions, those provisions are the type, reasoned the court, that actually then are tethered to a specific federal crime. But when, like with crimes of child abuse, the I&A uses only a generic phrase, it's intentionally broad. And so, reasoned the court, it can include attempts without Congress expressly saying so. Nor did this panel believe that the generic definition of a crime of child abuse requires a culpable mens rea of knowing or recklessness as to the victim's age, something that the D.C. crime apparently lacks. While a state crime is not a crime of child abuse, unless that state crime indeed does have a culpable mental state, or mens rea, that's only as to the abusive act itself, explained the court, not to the age of the victim. Seems that the Fourth Circuit, like the Tenth Circuit, is also motivated by the fact that most states don't require such a mens rea and instead make child abuse and sexual abuse crimes strict liability offenses as to the victim's age, meaning that if the federal definition included a mens rea element as to the victim age, lots of state crimes would be excluded from the crime of child abuse definition. So, the Fourth Circuit affirmed. Now, when I originally did this decision, it was a much shorter week than it became, but I'm still going to do these final thoughts that came to me, and then from the attorney who represented Mr. Cruz himself. If you'll bear with me. From me. Is that such a bad thing? That is, excluding lots of sexual abuse of a child crimes from the definition of a crime of child abuse removability? Don't get me wrong, I'm certainly not condoning child abuse, but Congress expressly saw fit to make non-citizens removable for sexual acts against children at I&A Section 11A43A, the sexual abuse of a minor aggravated felony. I&A Section 237A2EI, in contrast, says nothing about sexual abuse. Reading child abuse to include sexual abuse when there is already an I&A provision for sexual abuse seems like a bit of a wildly redundant reading of a statute that serves only to heavily benefit removability. I wonder what the legislative history shows on that question. And the rest, well, is from Mr. Cruz's attorney, who was obviously disappointed. Here's what he wrote to me. He believes that other judges on the Fourth Circuit and elsewhere would likely agree with the arguments that Mr. Cruz made in this case, so he strongly recommends that practitioners raise the same arguments in other circuits. Quote, with respect to the first argument regarding inchoate offenses, the panel tellingly did not acknowledge matter of Ho, published by the BIA in 1992, which makes clear that grounds of removability that don't refer to inchoate offenses like attempt don't apply. The BIA recently issued an unpublished decision agreeing with this argument, which the panel, tellingly, also did not acknowledge. With respect to the second argument regarding strict liability crimes, the panel, tellingly, did not acknowledge Menendez v. Whitaker, published by the Ninth Circuit in 2018, which held that I&A Section 237A2EI doesn't apply to crimes imposing strict liability with regard to the victim's age. So this issue is subject to a circuit split. End quote. Counsel expressly advocates for a gong. I am not one to give them out freely, particularly when the decision itself doesn't recognize any split, and I haven't read the allegedly gong-worthy decision in 6 years, much less ever reviewed it on the podcast. Nevertheless, I respect counsel greatly. As such. And that is Marquez Cruz v. Garland. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview, that's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.